enjoying by meeting people from different countries and learning a lot about IPR. We still have very important resource speakers and guests with more topics to deliver and ideas to share. It's my great privilege to invite Shreya Chandrasekaran, the former Controller General of Patents, Designs, Trademarks and Geographical Indication and the former Technical Member, Judge, IP Appellate Board. We welcome you, sir. It is my honor to welcome our speakers for the session, Ms. Ivana Lauritsen from Argentina and Mr. Evgeny Koltsov from Russia. We welcome you all. To welcome Shreya Chandrasekaran, with a bouquet of flowers, may I request Mr. Sriram Iyer to please come forward. I would like to invite Mr. Ketan Bhatt to present flowers to Ms. Ivana Lauritsen. To welcome Mr. Evgeny Koltsov with bouquet of flowers, may I request Ms. Kajal Makwana to please come forward. Now, I take this privilege to introduce our first speaker of the session, Ms. Ivana Lauritsen. Mrs. Lauritsen graduated from Law School, University of Buenos Aires with a major in business law. She became intellectual property agent, graduated from the Argentine Technology, Quality and Industrial Property Department, Ministry of Economy. Ms. Lauritsen has a master's degree in intellectual property from the Austral University by an agreement with the Worldwide Intellectual Property Organization. She collaborated as a teacher of the chair Business Intellectual Property from the Business Law Master's degree of the University of Palermo. She was also speaker at Expotun's 2010 International Congress of Cartoon Authors. She is frequently consultant and guest in TV and radio programs regarding her major in intellectual property. To speak on the topic, changes in the Argentinian trademark law, may I request Ms. Ivana Lauritsen to come on the dais.
Well, good afternoon. First and foremost, I would like to thank all the people of macpatent.org for this wonderful organization and the hard work you have done these days. I also thank the entire Acharyas family, not only Mr. Rakesh, but also Amkar and his wife too. Thank you. You have been wonderful hosts. I also want to thank you for being here at the end of the day. So I will try to make this good for you. Secondly, I want to apologize because of my English. It's very basic and my pronunciation is not so good because I live in Argentina and as Katia explained us this morning, we speak Spanish in all Latin America except Brazil because we were conquered in the 15th century by Spain. So we have a strong influence from Europe. Well, let's start the presentation. I have this. Well, during last year, there have been many changes in different intellectual property laws from countries of Latin America as a consequence of the Intellectual Property Key Latin American program, which is a program implemented by the European Union Intellectual Property Office. You must be wondering why the European community is interested in what happens in the legislation of other continents. Well, the fact is that according to the Foreign Direct Investment in Latin America and the Caribbean 2018 report, the 31% of all cumulative FDI assets comes from European countries. Before, Pier Paolo told us that the 22% of the worldwide commerce was from Europe. Well, part of that commerce comes to Argentina and Latin America. Most companies, European companies in my country, are in the fields of renewable energy, telecommunication, and automotive sector. Well, the European Chamber showed its concern regarding the protection of said assets and deepened its research in a study carried on with the Organization for Economic Cooperation and Development. It concluded that at a global level, 2.5% of commerce worldwide, that is 300 billion euros, is the fruit of infringed product commerce. It's a lot of money we lose due to counterfeiting. That's why the European Chamber conclude that they must defend European inversion in Latin America. Well, among the problems they had detected in Latin America, basically they were slow registrations of trademarks and patents at the local offices. In particular, in my country, the regular procedure of a trademark takes a year, but if it receives a position, it could take from 3 to 8 years to obtain it. The patent, it takes about 5 years if you have no office actions. In other countries of Latin America, as Brazil, takes more time. Well, the second problem was the lack of protections of some signs. Carolina told us yesterday that Colombia changed its legislation, and they now can protect certain signs of some names of national trademarks. Well, in Argentina, we didn't have this problem because our law is very open. We protect all kinds of signs. We only ask that it must be distinctive. Well, the third problem was the lack of specialization of judges. This was resolved by organizing this kind of seminars and conferences. And now we are thinking about creating new courts specialized in counterfeits. The fourth problem was the weak protection in custom offices in many countries of South America and Central America. In my country, luckily, we don't have this problem because we are members of an international system that can protect the products in the borders. Well, this program is led by Argentina and Mexico offices. It has a budget of 6 million euros, and they will have 4 years to put into practice all the required things that they believe must change. So, now we will say about the main problems in Argentina. There are two. The great number of trademarks that are registered and that are not in use. These trademarks obstruct the registration of new ones. And the second problem is the slow registration, as explained before. So let's talk about the first problem, which is the great number of registrations. Once you apply for a trademark in Argentina, you pay the fee for the application, and if it does not receive any opposition nor objections, it is granted in a year from the application. As no granting fees are paid, the trademark will be valid for 10 years. So, if you lost interest after the filing, you will have a trademark for 11 years, abstracting others that maybe will need the protection. Well, this was resolved by changing the law and establishing a statement of use, even though it is not yet regulated because we are waiting for the National Office resolution to put in practice, but they fixed the fees, so it will be in very few time in practice. Well, the statement of use is that between the 5th and the 6th year, you must declare that the trademark is being used. It's not a new system. It is in practice in Puerto Rico and United States. We don't know what will happen if you do not file this statement, because as it is not yet regulated. But we believe that when you renew the trademark, you will have to pay a penalty for each year that you haven't paid from the 5th to the 10th year. It's why, because they have fixed the fees for this penalty too. That's why we believe the resolution of the INPI will be so. Well, the second way of whipping up these trademarks is that related with the cancellation for lack of use. In our old law, there was a section that says that at a party's request, this means that it is not automatically, and that the INPI, the National Trademarks, could not apply for it, okay? At a party request, a trademark that has not been used in the country within the 5 years. We are very generous, because in other countries, the time that you have to use is less. For example, Carolina, don't blame me mistake, but I believe that you have 3 years in Colombia. No? I don't know, how many years do you have here in India? 5 too? Ah, like in Europe. Okay, you are generous too. Well, so that has not been used in the country within the 5 years prior to initiation of such legal action shall be declared cancelled unless there are force majeure causes. I had to explain that the cancellation for lack of use must be filed in the High Court. It is not an administrative procedure. You just want to apply for this cancellation. You call for a hearing, and if you do not reach an agreement, then you can start the trial. Well, there shall not be cancellation if the registered trademark that has not been used in one class has been used for the commercialization of a product or the rendering of a service included in other classes, or if it is part of the indication of activity. You see, we're generous, because if you use a trademark, for example, for a cookie, it avoids the cancellation for lack of use for clothes or perfumes. Well, so the use of any products or services avoid any class cancellation. That is the old system. The new one says, the Argentine Intellectual Property Office, ex officio, that change. Or at a party request, in accordance with the relevant regulation that it says that for now you have to start it in the federal court, but they are wishing to change this, will allow them to change the procedure and start it in the administrative office. Okay? Well, shall establish the cancellation of trademark either in whole or in part. This is also a change because with the old system, there were no partial cancellations because if you prove the use in one product, it is not being cancelled in others, then partial cancellations were not allowed. Now they are in force. Well, either in whole or in a part, regarding the products or services for which the trademark has not been used in the country within the 5 years that didn't change, prior to cancellation request, unless there are force majeure causes. A registered trademark that has not been used in a class or for certain products or services shall not be cancelled if such trademark was used for the commercialization of a product or the rendering of a service similar to the ones mentioned above, even if it is included in other classes, or if it is part of the indication of an activity related to the products and services mentioned above. So, if you prove a similar product, so the trademark will not be cancelled. In other countries, in Latin America, they are more strict, and you have to prove each product and each service. Carolina, I believe that you have that in Colombia. Well, I asked Carolina because she's from Latin America. Well, now we have to see that this is the new trend in legislation. The cancellation for lack of use is being used worldwide. And last month, it's a very new resolution. In January, Big Mac trademark has been cancelled in Europe for lack of use. It seems that McDonald's started a trial against Supermark to obtain the seize of the trademark, and Supermarks respond by asking the cancellation for lack of use. Supermark is an Irish chain of hamburgers. Well, it seems that the proof was not enough, so the European judge declared the cancellation. I don't want to be the trademark agent of McDonald's. Well, this was an opportunity for the competitive trademark to do some jokes. For example, there was a campaign saying, like a Big Mac, but really bigger. The hamburger Big Mac wishes he was. Anything but a Big Mac. Like a Big Mac, but juicier and tastier. And also, this advertisement was on TV, just to see you how important it is not to lose a trademark.
Jag skulle vilja ha en...
Anything but a Big Mac?
Kind of like a Big Mac, but juicier and tastier.
The burger Big Mac wish noodles.
Anything but a Big Mac?
I'd like a Big Mac, but actually big. Here you go. Thanks.
Big Mac-ish, but flame grilled, of course.
Anything but the Big Mac.
Well, the trademark is not enforced in Europe, but in other countries it is. Okay, so this advertisement was not for my country. Well, but I show this to explain how important is the proof, the evidence in a trial. And in the case of cancellation for lack of use is the principle. Now, well, so if we compare both systems, the old system established that the use of any products or services prevented any class from being cancelled. The new law, it's the opposite. The proof of use must be for the commercialization of a similar product or services. In the old system, we have no partial cancellations, and in the new one, we have. In the old system, companies used to apply for the whole class and the 45 classes, because as we didn't have to prove the use in any class, they applied for everyone, for all the classes. And now they only must apply in the classes that they use the trademark or are related to the product or services. So the defense trademarks, which were trademarks that classes that we applied just in case we will use it or because we didn't want others to use it, now are not even more in force. Well, and the old system, it was a judicial procedure. Now it is a judicial, but it is going to change to administrative. Well, the second problem is the slow registrations. As I told you before, the regular procedure takes a year, but if it receives an opposition, we have to initiate a judicial procedure. Let's see how it was. Well, the search is upon the client if he wants to do it or not, because the national office that doesn't obligate us to do the search. Well, once the application is filled, it passes through a formal examination, and then the publication is done in about 90 days from the application. Then we have a 30 days period for opposition. We are not generous as the European that you have 3 months. No, we have only 1 month. And if it received opposition from third parties, the INPI, which was the National Trademark Office, could not analyze the basis of the opposition. It only provides the applicant 1 year period time to obtain the withdrawal. And if the applicant didn't obtain the withdrawal, then the trademark was abandoned. It was a final resolution, irreversible. Well, so during this time that you have, and it was a year, a lot, you had to contact the opponent and try to reach an agreement. And if you failed, you had to call for a hearing, and if you fail in the hearing, then you had to start the trial in the federal court. As you must know, the federal judge have more important cases, like limits between the provinces. Well, you must know you have problems with Pakistan, so you can be imagined that comparing two trademarks was not what more important for the judge. That's why it used to take a lot of time to obtain the resolution. The main problem was that the INPI could only verify that opposition was filled within the 30-day terms, was signed by the opponent, and that we paid. So those were the only arguments that can be used by the INPI to obtain the withdrawal of resolutions, of oppositions. So it was a very large process. As I told you, the judicial process was very slow because federal courts had more important cases. It happened that the trademark with a pending lawsuit could also be seen as an antecedent in a later application, which was also blocked until the lawsuit was over. And this could also be seen in another trademark, and that was a chain of many trademarks blocked by the first one. There was another problem that an application with an opposition based on an abandoned trademark was obliged to initiate legal action ex parte. So, if I receive an opposition and the basis of the opposition was an abandoned trademark, even though I have to do a trial. Well, so it changed, luckily. Well, till publication, the system is the search, but when we receive an opposition from third parties, we have 3 months to obtain the withdrawal, and if we cannot convince the opponent, is the opponent who must seek the process to maintain the opposition. The opponent has to pay a fee that is very high. It's 5 times the fee you pay for the application. So you start this procedure, which is administrative, but it's like a trial, because you start with an amplification of the argument, then the answer of opposition, and then the more important is the period that you have to prove what you said, because this is the only stage you will have to prove. Okay? Then you obtain the resolution, and if you are not satisfied, it can be appealed. But the appeal will be direct to the second instance. So you will not able to add any other evidence. Well, so roles have changed. In the old system, the applicant was the one who had to seek the resolution of the opposition to get the trademark registered. And in the new system, it's the opponent who must seek the acceptance of his opposition. But we have problems with the new system. The problem is that the in-piece resolution may be appealed directly at the Court of Appeals, so no further evidence might be offered. We have to pay for each. Well, so, as a summary, I would like to keep this in mind, that in our country, 5 years after a trademark registration, holders must file a statement of use, that the trademark must be used for all products or services it protects, or those who are similar, and that the opposition procedure has changed, so the filing of convincing evidence before the administrative authority is now of utmost importance, due to the fact that further evidence won't be allowed in higher courts. So, thank you so much.
As a gesture of thanks, we request Shreya Chandrasekaran to present the memento and certificate to Ms. Ivana Lauritsen. Thank you, sir. And again, I request him to present memento and certificate to Mr. Evgeny Koltsov.